Welcome to a talk with Robert J. Caron of Caron Law Office in Providence, Rhode Island. In this video series, Attorney Caron will discuss some of his primary areas of practice, which include criminal law, family law, commercial fishery, personal injury, civil rights violations, and criminal record expungement.
My name is Rob Caron. I'm an attorney practicing here in Providence, Rhode Island. I'm in private practice. My practice is somewhat of a general practice, but with a real focus in criminal defense work, family court, domestic relations, child support, divorce, custody issues. I also have a focus in representing commercial fishermen. Incredibly enough, there is a vast body of regulatory regulations that deal with commercial fisheries, as promulgated by DEM in their Fisheries and Game Department. Oftentimes, these commercial fishermen can find themselves being named a defendant in a criminal setting for violating certain regulations established by DEM. But I've been at this for almost 20 years. Right out of law school, I started my own practice with a focus in criminal defense work. I'm licensed in all of the state courts. Of course, I have argued before our Rhode Island Supreme Court numerous occasions. I have twice been on a writ of certiorari to the United States Supreme Court. I'm licensed in the First Circuit Court of Appeals, the Federal District Court in Rhode Island. But most of my practice is in the criminal courts in Rhode Island State Court, in the Superior Court, and District Court. Another part of the criminal defense practice that you see day in and day out is the DUI charges or the refusal charges. Those affect every socioeconomic landscape out there. It's a serious offense. It's very, of course, politically charged in the state, but people are entitled to a defense. There are things that can be done to minimize sanctions that one may be exposed to, but certainly anyone who's charged with such an offense, stands the chance of losing not only the privilege to operate a vehicle in the state, but a criminal conviction, maybe a criminal conviction versus a civil penalty on the refusal side is something that's much more disturbing for someone to be facing, and oftentimes you can trade off one for the other. Oftentimes you can win those cases as well, because you have to start with why were the police, why was law enforcement stopping that vehicle on that day? What's the reason that they put forward? Is it a pretext, or was it a legitimate stop? And if it's not a legitimate stop, and there's no reasonable suspicion or probable cause to pull someone over, then the dominoes start to fall, and the state's case can fall apart on a DUI and or refusal case. So I've done many of those cases with great success, trials, and numerous dispositions. I'm not going to sell you a bill of goods. If it's a case that has problems, you try to minimize the impact and do the best that you can, always with the client's best interest at the forefront. Kind of an offshoot of criminal defense work, and it's very important to many people, is our expungement statute. It's a rehabilitative statute, and we have probably one of the most liberal expungement statutes, laws in the country. And essentially, it's not something that developed over time, common law, as we lawyers say. It's a creature of statute. It's legislation that was passed by our General Assembly. And essentially it gives folks another chance, an opportunity to wipe the record clean, to be able to say, under most circumstances that you've never been arrested or convicted of a crime before. So this expungement statute really has two components. One we call the motions to seal, the other type are the motions to expunge. Essentially they're doing the same thing, they're getting something off of your record. But the motion to seal may be less stringent as far as requirements reaching that statutory threshold of whether you're eligible or not. And that is because motions to seal are based upon charges which have been brought against someone and ultimately they were exonerated. That could be by way of a not guilty finding after trial or a straight out dismissal by the Attorney General's office. So if the case is dismissed or you are otherwise exonerated, you should be entitled to a sealing of those charges. The expungement statute has some overlapping criteria, but essentially expungements deals with charges which the state has secured a conviction or a period of probation, and you generally, if it's a felony case, you have to wait a period of time, specific period of time after that probation sentence has ended before you can go to the court and ask the court to expunge your record. And of course, as you can imagine, it's supposed to be used for first-time offenders and other criteria. So if you have a record that goes back, a couple of decades and a multitude of charges, don't waste your time going into the district court or the superior court to try and wipe that slate clean, because it's not going to happen, unfortunately. That's up to the legislature, and there have been things that have been pending before our General Assembly to eliminate the rather strict requirements for expungement. And so the argument has been to give more discretion to judges to permit people to rehabilitate and meaningfully join society as a productive member again, because of course, as difficult as things are today, especially and over the last few years, if you have a criminal record, it's difficult. Employers don't look for that kind of thing, and it may affect your opportunity or ability to get employment, meaningful employment. If you are eligible for expungement or a sealing of a record, that's something I can pretty quickly look up, and it can have some nuances, but I'm certainly not going to take someone's money to come in here to file a motion to expunge their record when I know they're not statutorily eligible. So don't let someone sell you a bill of goods on that. It's pretty clear who is eligible and who is not. When you're charged with a felony in this state, the Attorney General's office has a 6-month window of opportunity to review that case that, say, a local charging police department has brought, and determine whether, in fact, it warrants being continued to be charged as a felony. That we call in the state information. So if after a certain period of time the Attorney General determines that in fact there is enough evidence or probable cause to sustain, at least in their mind, a conviction for a felony, they will charge it as such, and the case will then proceed over to the Superior Court. But all of that information review, if you will, is taking place while bail has been set on the initial presentment in the district court, and the Attorney General's office is reviewing it. They may also, during that period of time, be seeking an indictment through the grand jury, and that would be, again, for the most serious of cases. But otherwise, Most felonies come by way of information charging after the initial complaint has been filed in the state.